Mendoza versus Leanna Noreen LeBaron in the courtroom. Do I have Jennifer Lynn Mendoza?
Yes.
Good morning to you.
Good morning.
Counsel, could I have an appearance, please?
Hello, Your Honor. This is Corey Briggs for Respondent Leanna LeBaron, who's also listening in on MS Teams.
Understood. There is media recording, just so you're aware of that, counsel.
Thank you.
Good morning, Ms. Mendoza.
Good morning.
As you recall, we had a hearing some time ago when we ordered a cooling off period. How have things been?
Well, I'm here to ask the court to extend the temporary restraining order. Although Ms. LeBaron has not violated the TRO in the last 90 days or harassed me any further, I have good reason to believe that the minute this order is lifted, she will start harassing me again. Her father's girlfriend had to file a TRO twice against her.
Okay, ma'am, let's focus on behavior directed at you, not relating to any other filings against the respondent.
Okay. Okay, well, because multiple TROs have had to be filed by the same people, I'm concerned that I will have to do the same thing. So that leads to my concern. Based on her past behavior, I'm convinced that she's going to come after me as soon as this order is lifted. She has a history of violence. Her husband has stated in court and in filings that he has proof of this. I don't know that she would be violent towards me, but I'm 68 years old. My husband will be 80, and I am concerned for our safety. At the previous hearing, I tried to show a pattern of increasing harassment and stalking by Ms. LeBaron. I'm not the only one she has harassed and stalked. And I presented that evidence at the previous hearing regarding her husband and her father's girlfriend. Several city staff members, including the mayor, have filed workplace harassment complaints against Ms. LeBaron.
Okay, ma'am, let me stop you. Let me try and explain. Hearsay is admissible, but if you wanted to bring these matters to our attention, you'd bring those people in to have them testify. So you're not doing that, so I understand
Okay.
Those allegations exist. It's like the other evidence, the court's considered that. So is there anything else you'd like to add before we talk to counsel for the respondent?
Yes, there are some things I would like to add. I do have evidence. One of the complainants at the city, our city clerk, who has since quit. I have the investigative report from the attorneys who were hired by the city of Lemon Grove to investigate the harassment complaint made by the city clerk against Ms. LeBaron. Ms. LeBaron has shown no remorse for her behavior toward me or anyone else that she's harassed. In fact, she minimizes and or denies her actions. I would like a 15-month extension until November of 2024. Her city council term is up at that time. I think it's unlikely that she would, if she even ran, that she would win or be reelected because of her negative behavior. Once she and I are no longer serving on the council together, I think that she will not have a reason to harass me and will leave my husband and I alone. As you know, the burden of proof in a civil harassment restraining order is clear and convincing, which is lower than the standard of proof in a criminal case. This means I merely need to show that the facts in dispute are more likely than not. Extending the TRO would not be a hardship for Ms. LeBaron. We don't have the same friends or belong to any of the same social clubs. Her child and my grandchildren don't attend the same schools. She doesn't go to my church. I've rarely seen her out shopping or dining out. We seem to frequent different businesses. In the last 90 days, I received an invitation to a dance recital, but I believe that her daughter was dancing in it, so I did not attend. I did not go to several of our local concerts in the park because her friends were there, and I thought that she would probably attend, and I didn't want to make it difficult for her. We recently had an event at the city, and I went early, she went late. I left a community meeting on homelessness early so that she could attend after I left. I have every intention of avoiding her if at all possible. In conclusion, extending the TRO will not prevent Ms. LeBaron from doing her job as a city council member and will not substantially inconvenience her. However, it will protect me and my elderly husband from continuing harassment and stalking by her.
Council.
Thanks, Your Honor. A number of points. As I'm sure you're aware, the more likely than not standard is not clear and convincing evidence. Furthermore, all of these issues were litigated previously, and that's why you continued the matter through today. As Ms. Mendoza said, there have been no incidents since the hearing, since the TRO, in fact. So there's really no reason to continue things. There's also no provision, once the merits hearing has been held, for the court to just backtrack and continue a TRO, despite there not being a permanent restraining order. My client would object to any continuance of the TRO. Furthermore, as Ms. Mendoza just said, she has managed, and my client has managed, to work things out so that they don't have to deal with each other outside of city council meetings, and there have been no incidents whatsoever. Why is any sort of restraining order required for that? They managed to handle things just fine. So there being no evidence of any sort of future threat, there being no evidence of a continuous course of conduct, many of the things that Ms. Mendoza wants to bring back up were stricken by the court in the anti-SLAPP ruling. And so my client would ask that you dismiss the case today.
I understand, thank you for that. I do have a couple of questions for your client before the court makes its ruling. Ms. LeBaron, good morning, can you hear me?
Good morning, Your Honor. Yes, I can hear you.
Yes, just a couple of questions. If you could raise your right hand, ma'am, we're going to put you on the oath.
All right.
Yes, ma'am. Is your hand raised? We can't see you.
Yes. I believe I have my camera on. Do you see me?
No, ma'am.
We don't. It could just be a bug. It's okay. Just please keep your hand raised and take the following oath. Ma'am, do you solemnly state under penalty of perjury that the testimony that you will give in this matter will be the truth, the whole truth, and nothing but the truth? And if so, please say, I do.
I do.
Thank you, ma'am. You can lower your hand.
Thank you.
Yes, good morning, ma'am. Just a couple of questions. As I asked you before, but I'm going to ask you again. Does the petitioner have any reason for you to contact her in the future unrelated to lawful contact related to your business?
No.
Are you voluntarily agreeing that you will not call, strike, harass, contact her in the future unless lawfully related to the business relationship?
Yes.
Okay, if you happen to come into contact with the petitioner in a random encounter, what will your behavior be, ma'am?
Normal behavior. If I'm walking through a grocery store smiling, I'll continue walking through the grocery store smiling. If I'm driving on the street looking to the left, I'll probably continue driving down the street looking to the left. Yes.
Understand, thank you for that. So ma'am, let me address some of the issues you raised. First, the standard that the temporary order was issued on was reasonable proof of harassment. The standard today is clear and convincing, and here's the definition of clear and convincing. Clear and convincing evidence requires a finding of high probability. Under this standard, the evidence must be so clear as to leave no substantial doubt, sufficiently strong to command the unhesitating assent of every reasonable mind. That's the second highest burden of proof that we have, and it's much higher than what you suggested, reasonable proof of harassment. So, also, the court finds that there is not a reasonable probability of unlawful violence in the future. Now, you have raised the issue of what happens in the future, all right? Now, you've heard her testify under penalty of perjury as to what her behavior is going to be. If she is not consistent with what she just testified to again, then you can simply refile the order downstairs, and we're gonna have an entirely different conversation the next time we see each other. So the temporary order is dissolved, and thank you very much. Have a good day.
Your Honor, there's one remaining issue that you said we should bring up, and that is the motion for the attorney's fees on the anti-SLAPP. We agreed to wait until today to set a hearing.
Yes.
Do I need to call your clerk to get a date, or do you want to give me a date now? What's your preference?
They'll give you a 30-day date when you file it downstairs, sir.
Okay,
That's the
great.
motion. Thank you. Have a good day.
Thanks, Your Honor. Bye.
Thank you, Your Honor.